We now go to a question period where we each have a chance to ask questions with the 5-minute rule imposed upon us. And I will begin by recognizing myself for 5 minutes. I'll start with Ms. Catherine Lehman. Until May of this year, the Civil Rights Division under the Trump administration did not file, as I understand it, a single case enforcing Section 2 of the Voting Rights Act. Can you explain this shortcoming, if you believe it is one? And if it is such, that do you believe this, as some might claim, that there simply isn't much voter discrimination going on?
I think there's no question that there's substantial voter discrimination still taking place. That was a unanimous finding of the U.S. Commission on Civil Rights. And the failure to file litigation using a tool that Congress funds the department to use is astonishing to me and inexcusable. I want to really concretize that by recognizing that the ACLU alone has filed more cases than the Department of Justice has to protect voting rights in this country. Likewise, the Lawyers Committee for Civil Rights has filed more cases itself than the United States Department of Justice has. That nonprofits are bringing more litigation on behalf of American voters than the nation's litigator charged by Congress, funded by taxpayers to do that job is jaw-dropping and inexcusable and leaves voters profoundly unprotected. Separate and apart from the number of cases brought, voting rights cases are among the most challenging cases to litigate, among the most expensive cases to litigate. They take a long time, they require experts, they are enormously challenging to prosecute to completion. And to see the Department of Justice absent in this area, when we know and we have documented all across the country that there are ongoing voting rights challenges for voters with disabilities, voters with language access issues, and for voters of color in this country, that we don't see the department active and litigating in that area is a crisis for the country.
Thank you very much. Ms. Eiffel, communities of color have experienced years of police misconduct, and they're distrustful of their police departments. We see it in Louisville and Minneapolis, et cetera. How can an outside investigation by the Civil Rights Division remedy this systemic misconduct and start to alleviate the distrust? And how would you rate the division's performance under the Trump administration in this regard?
Well, the performance has been, frankly, abysmal. In the years of Obama administration, the department was taking a very aggressive role in addressing police misconduct. Communities responded to the presence of the Attorney General, to the presence of lawyers of the Civil Rights Division in Baltimore, in Ferguson, and in other cities. Members of the community regarded it as important that the federal government, that the Civil Rights Division of the Department of Justice was being attentive to these longstanding systemic issues that local communities have had with police departments. The current Civil Rights Division not only has pulled out of pattern and practice investigations, which really is the most important tool to get at systemic discrimination in law enforcement. They have tried to frustrate the efforts to do those kinds of investigations in other fora. You already heard that they really attempted to reverse themselves in the Baltimore case, but they were stopped from doing so by the federal judge. They also filed a statement of interest in Chicago when the state of Illinois filed its own pattern and practice investigation against the Chicago Police Department. The Department of Justice submitted a statement of interest, essentially suggesting that they should not enter into a consent decree. This is a case the department was not even part of, but they wanted to frustrate the efforts of the state of Illinois to do what the department had failed to do. So this is actually quite serious indeed, not only the absence of the Civil Rights Division in aggressively entering the space, but also the effort to frustrate the attempts by others to try and address systemic unconstitutional policing. The law enforcement misconduct statute was passed after the unrest following Rodney King's beating in Los Angeles. And that statute empowers the Attorney General to do these investigations, and it essentially sits dormant. So the Attorney General essentially has made the decision, and the Civil Rights Division has essentially abdicated its role. It's under an authorized statute to do this work. It lies dormant, unused by the department because they've chosen not to do so.
Thank you.
And much of what we see
Thank you,
today,
Ms.
the
Eichel.
frustration we see around the country, is a reflection of that.
Thank you, Ms. Eichel. Mr. Sessions had said that bringing these type of pattern and practice investigations reduced officer morale and suggests they had the effect of increasing crime. That seems analogous to their not appearing before our committee because we hurt their feelings once. Do any of y'all believe, Mr. Smith, I guess, or Ms. Eichel, that we should not have pattern and practice investigations for concern that we might be reducing the officers' morale?
Representative Cohen, I met with Attorney General Sessions early in his term, and I shared with him the existing scholarship that actually demonstrated the contrary. And I shared with him the way in which we increase the morale of the police department by increasing trust with the community, and community trust is increased by ensuring that there is not unconstitutional policing. I shared this with him directly. His view is unsubstantiated and simply untrue. And as we can see, I think things have deteriorated in this country around policing, largely because of that decision by this department.
Thank you very much. And I now yield to Mr. Johnson for